So discrimination at work in employment law, that's obviously a very thorny issue, and if you are suffering from discrimination at work, it can be a very bad time for you, and you'll want to put it behind you as soon as possible and move on. Ideally with some kind of justice. Now, you may have realised already it's very difficult to win employment tribunal claims, and it's very stressful, and even if you do win, it's questionable what kind of outcome you're going to receive from that. Normally it's just a financial outcome. Employment tribunals can't turn back time. They can't make that person that's discriminated against you take back what they did. So it's really just a financial element that they can award you. So for us at Monaco Solicitors, we're very much involved in negotiating settlement agreements and exit packages for people who are leaving work, often when they've been badly treated, and that includes if you've been discriminated against. It's often a lot better to negotiate yourself a settlement, a lot less stress and a lot quicker, and it can be the same kind of money and just allow you to move on with your life, knowing that you didn't just kind of let it happen, but you actually can leave with your head held high. Now, there's a few specific points to look out for within discrimination scenarios at work. There's a broad range of different types of discrimination, you'll be aware, from age, disability, gender, through to nationality, race, and religion, pregnancy, and other types. So within those, within a specific type of discrimination, there are, under the Equality Act 2010, there are different types of discrimination. So you've got direct discrimination, indirect, and you've got failure to make reasonable adjustments. The reasonable adjustments thing is just for disability, which means that they haven't, for example, if there's just stairs in the building, they haven't put a lift in, that's reasonable adjustments. Those can be justified by the employer by saying, well, we don't have the money to put a lift in. So that's not a cut and dried, open and shut thing, reasonable adjustments. That's got to be measured against how reasonable is the adjustment. Other types of discrimination, and also disability as well, have this direct or indirect. So direct would be saying, you are this or that, it's literally sort of pointing the finger at someone or making their life more difficult because of this protected characteristic they have, whether it's age, gender, race. Indirect is bringing in a new rule into the workplace which would disproportionately affect people with this characteristic. So it would apply to everyone. So it's not saying, oh, you are this, you're that, but it's bringing in this general rule, but it actually disproportionately affects someone with that protected characteristic. Again, with indirect discrimination, that can be objectively justified by the employer, so that's a matter of fact and degree. And then each of these types of discrimination has their own little sort of section in the Equality Act, so it really is quite a complicated technical part of law. And if you are going to go to the Employment Tribunal, it's really important to get your ET1, which is your Employment Tribunal claim form, and there's lots of examples of those on our website you can adapt. But it's really important to get that right, because if you miss out a section of the Equality Act, or if you plead it incorrectly and you say it was direct when it was indirect, or you say it was failure to make reasonable adjustments when it was something else, then you can find yourself out of time later. So there's a 3-month time limit for discrimination claims, and you don't want to be on the wrong side of that 3-month time limit. On the plus side, you can negotiate yourself a deal often if you have got some evidence, ideally witnesses or emails or maybe even audio recordings, but if not, at least a diary of events and some kind of evidence. Once you've got that, you can negotiate yourself a settlement agreement, exit package, because employers who are guilty of discriminating against an employee really generally don't want that to be public knowledge. It's not just like an unfair dismissal or constructive dismissal or a sham redundancy or something. So you have got that leverage. Now, if you don't have any evidence, try the questions procedure, which is a discrimination thing whereby you can ask written questions, and your employer has to reply, like, how many people with this characteristic have they employed, or how many people with that characteristic have they disciplined or dismissed or made redundant. So specific questions, again, examples of that on our website. Once you've got your evidence together, perhaps present that to the employer in a without prejudice letter or meeting, rather than going down the formal grievance route at the very first step, because they will feel obliged to investigate that formal grievance. Whereas an off the record or without prejudice approach from you, whether it's correspondence or a meeting, they can sort of sweep that under the carpet, and at the end of the day they can negotiate a deal with you and sort of keep it confidential. And for them, that's probably better for them. I mean, ideally they won't do it again either way, and either way the manager, or whoever it is involved, the perpetrator, would be either disciplined or dismissed. But like we said at the beginning, you're not going to be able to rewind the clock. So ultimately, if you're leaving there with a decent negotiated settlement agreement, you can leave with your head held high and hope that they just won't do it against someone else. If you have any specific questions or want a free consultation, please get in touch with us. Looking forward to hearing from you. Thanks.